today on the oral argument calendar is Cassiano versus Cassiano, case number 2310. Counsel would come forward.
Go ahead and approach.
Would you like to reserve any time for rebuttal response?
Yes, sir. Please 5 minutes for rebuttal.
Thank you. You may proceed.
May it please the court, my name is Ron Vargas, and I have the privilege of representing the appellant, who's Alexandra Cassiano, in this matter. This is a partition action, which is, although sounds and equity, is governed by statute. And two of the main issues that I wanted to address are the imposition of a constructive trust in the amount of $108,000, which was applied to the sale proceeds before partition counting was made, before the credits were done. And the second issue would also be the attorney fee issue. If there's any concern about the jurisdiction, I'll be glad to address that. I do think it's clear that this court does have jurisdiction from this final judgment, which dealt with the accounting proceedings, including the constructive trust. The briefing was done under the first. I will want to bring this court's attention the Fifth Circuit's case of Shepard, where basically kind of addressed that whole issue as a partition order itself is appealable, and the Fifth District said it's a non-final order, but could be appealed under 9.130 under property. So this court does have jurisdiction to determine how the court apportioned the surplus proceeds in this partition action. And the issue with constructive trust, this was, you can look at the pleadings, you can look at the pretrial stip. The parties were going to the court to determine they were 50-50 owners, joint tenants with rights of survivorship. What credits were they to be, how they were supposed to credit to make up for expenses and expenditures that they did in relation to property. The plaintiff's joint pretrial stip basically says we're going to see credits, including payment of mortgages and things. Now, at trial, there was discussion of this $108,000 because the plaintiff's position was that this money, which was related to the property but paid a year before joint ownership, should be deemed a credit or on top under partition law. The plaintiff specifically cited the Biondo case, used the term credit. I bring the court's attention to page 11 in opening argument, page 208 in closing, also the pretrial stip. The plaintiff's arguments was this should be a credit in the partition. And then they presented two arguments on how that credit should be calculated, either off the top, which we would argue is there's nothing in partition law that deals with that, or as a credit, just as the other expenditures, in which case you do the Biondo and Biondo. The defense position at trial was that there was in the body of partition law that when you make a payment as part of a joint tenancy rights or survivorship, that it is presumed when that payment is made at the same time that the joint ownership arises, that it's a gift. So in other words, defendant's position at trial was you can just ignore this because they have to show clear and convincing evidence that this was not a gift.
I have some questions about the issue.
Okay.
Ms. Vargas, and you started things off by saying partition actions sound in equity and are governed by statute. And I'd like to ask you about the text of statute section 64081. Would you agree that the text of that statute would allow for, hypothetically, to award fees to one side but not the other?
The court would have to make a finding that there were no services of benefit to the partition, and in this case, the trial court specifically found that the services by my client's attorneys were of benefit to the partition. And that would require that finding, and that finding is actually contrary to what the court found.
And thank you for that answer, Ms. Vargas. Bogus, but you would agree, again, hypothetically, that the text would allow that, assuming there was no benefit related to the partition.
Yes, I think most of the case law says that's very rare. I mean, most of the cases say that as a matter of law that both parties are entitled according to the proportion. But theoretically, the statute does require and of benefit to the petition. So I would, say that is what the statute says.
It does say that, and it does say ahead of that, to plaintiffs or defendants' attorneys or to each of them, which suggests that you could have a one-sided fee situation where it was not a benefit to the petition. Correct? What do you make of, if you do, the argument that was made below? I know you're not involved in this, you're not trial counsel, saying that plaintiff should bear her own costs. Obviously, the plaintiff is the appellee on this section and should not receive a credit against the proceeds. Does that cut against the argument you're making in front of us today?
No, I think that what was going on there was that whether those services were a benefit to the petition or whether those services were relating to maybe the acrimony and the relationship between the parties, is that whether the services perhaps were not of benefit and had extended the partition.
They weren't phrased that way, were they? That argument wasn't presented in that vernacular of the trial.
There was some argument that the plaintiff had opposed things in relation to the sale, and all of that. That's in there. But we've not attacked the court's decision to award the plaintiff her attorney's fees and to do that as a partition. That's not part of it because that was within the trial court's, that was, and in fact, the amount of fees were stipulated to in terms of the amount of costs were stipulated to.
And following up on Judge Sal's question, I'm looking at sub B of the response. It says plaintiff is not entitled to an award of attorney's fees because her behavior during litigation has been equally, if not more, vexatious. I don't see anything in that language talking about a benefit to the partition. So, having read that, Ms. Bogus, is your client bound by that from a sense of inviting error, perhaps?
Inviting error for the award for the plaintiff?
Yes.
We have not attacked the award to the plaintiff.
Well, but you're saying that there was a situation where the activity of the lawyer could be vexatious enough, not entitling that attorney to fees. I mean, that's the very thing that was said here and was said in a couple of other places. So that seems to cut against, to this judge, against the argument that you're making in front of us that there was no way for this court to do anything other than to give both sides fees related to this case.
Now, my argument, Your Honor, is that the trial court specifically found that my clients, the attorneys, provided services to the partition. That finding was not attacked on the cross appeal. That is a specific finding in the order on attorney's fees. And given that the trial court, who of course had everyone in front of them and was basically in the best position, made that determination, that the trial court made the determination which stands, that it was of benefit to the partition. She made the determination that both sides provided services that were benefited to the
Did trial counsel for your client present a request for attorney's fees expressly rejected by the trial court?
Yes, it was not an entitled, let me just go to the beginning. There's in the answer, it's in the pretrial step, at the beginning of the trial, there's a statement, we're also seeking attorney's fees as a credit. So that's also, we're talking pleadings and a trial. After trial, in memorandum in opposition to their motion for attorney's fees, they requested attorney's fees. It was not a titled motion, they requested, provided affidavits, provided reasonable attorney fee affidavits. All of this was before the judgment. So the only thing they did not do was to file a paper that said motion under Rule 1.525 seeking attorney's fees. Attorney's fees was obviously litigated, everybody agreed, and it's because the attorney's fees are part of the petition action. They're part of the 64-081, and that was understood by everybody on that basis. So yes, it was rejected because the court did not award. Did the court in the order say, I'm denying it? No. But the order on attorney's fees that was entered only awarded it for the plaintiff.
It's wholly silent
It is silent. It is silent in terms of,
as to appellate fees or defendant's fees.
yes, other than the fact that they had made that they had benefited the partition. There is nothing in the order about whether there's a motion, there's nothing in there. But the record is clear that request was made consistently from the beginning of the answer at trial and post-trial, and was not awarded. And again, this might be a situation if it was a jury trial, we have different things, but this is certainly something we believe that is preserved under 1.530, and the fact that it was in, we have that finding, but not an award. I do want to go back to, if that's it on the attorney's fees.
I do have one more question.
Yes, sir.
Ms. Boggs, about the fee issue. And again, hypothetically, given the equity power of the court under the fee statute, can you envision a circumstance where counsel's behavior would be so over the top and vexatious that they would forfeit their right in equity to a fee based on this fee statute?
I'm not aware of this case that addresses that, but if you have a scenario where there were specific findings made by the trial court, which would allow that to be almost as a sanction, and there had been notice and opportunity for that to be addressed, when they would in fact lose their statutory right to attorney's fees for fraudulent behavior towards the court or some kind of vexatious behavior, that may be within the realm of the trial court's discretion, and in their authority as a trial judge. But that's not happening here. There is no finding, there is no determination that anything was done which would prohibit them from gaining attorney's fees where there's a finding that it benefited the partition. So the trial court judge went out of his way to say, yes, you benefited the partition. And in fact, my client's credits, if you leave aside the constructive trust, were quite substantial. They were higher than the other side's credits.
Humor us for a minute. I know what you said about 1525, but there are the statutes of legion where the legislature has said that a party that prevails shall be entitled to fees. So if you prevail, you shall be entitled to fees. As a matter of fact, Section 769 says that very thing. If you meet the proposal of settlement, offer of settlement guidelines, you shall be entitled to fees. All the cases interpreting those statutory texts say that you still got to file a motion for fees under 1525. Why is this statute different?
Well, the statute is talking about awarding fees in proportion to proportion of the interest. So unless you had 100% ownership and a 0% ownership of the partition, that would not apply. There is also a case law that says the statute is not a prevailing party statute. This is not one where one side wins, one side loses. This is the dividing of the fees as really a credit. It's not a damage. This is a credit on behalf of the equal ownership. So that if, for example, there was a partition trial and the ruling was you, plaintiff, have the 0% ownership interest, then it would be in effect a prevailing party, and only the winning party, the 100% owner, would get it. But because the statute requires you to divide it in proportion to the party's interest, and there are 50-50 owners here, you are required to award attorney's fees on both, and the case law does address that and say that this statute is not a prevailing party. As to the motion itself, I mean, I have presented arguments. I do think that the motion was presented. But there is also the whole idea that attorney's fees as well as credits are not damages. They are not separate awards. They are not executable awards. You can go out and get rid of execution. They're credits. And so whether that rule even applies when you're talking about, you're not seeking a judgment taxing cost. You're seeking an additional partition credit under partition law, under the case law, and under the statute. And that's a difference on that way. I do want to go back, because I'm almost in my rebuttal, because I do think there was a major error in terms of the constructive trust, because what the court was addressing is it appropriate to give credit for the payments made? And there was arguments relating to partition law only, Biondo, all of that under the credits. What the trial court held was that it was not appropriate to give credit because this was a year earlier, and under Fernando's case, you cannot do that. It's not a partition credit. And the court also ruled that it went in resulting trust, which really had to do with the resulting trust gift issue. Having made those rulings, the rulings that were being pled and were tried were resolved. And the trial court's award of a constructive trust, which is based on unjust enrichment cause of action, or fraud cause of action, or mistake cause of action, and has specific elements that have to be proven, was inappropriate to do that, where the opportunity to present evidence, the opportunity was gone. It was not tried. And the case law is also legion. The courts have handled it different ways, but that if it's an issue that is not tried and not pled, that it is either fundamental error, it's avoidable. I think the Supreme Court uses the position, judgment outside the pleadings cannot stand, and it's at least avoidable on appeal. And this is in fact that scenario. There was no unjust enrichment that was being tried. The whole discussion was under the partition law, and that was the only count. And accordingly, since partition does not allow for credit for that amount should not have been imposed on top of the surplus. And the result of which was that the dividing the partition was not a 50-50 with credits, making them a full 50-50 ownership. She was allowed to take 30% of the proceeds of the top. I'm going to preserve the rest of my time for rebuttal. Thank you.
Good morning, may it please the court. My name is Douglas Weiler. I'm the law firm of Jacob Schultz and Weiler. We represent the appellee, Ms. Florence Cassiano, the mother of the appellant. I'd like to begin with the motion to strike that we filed as claiming this appeal is untimely as to order of partition. We filed that back in September 17th to 21, and there's an order from the DCA saying that it would be before the panel to rule on the merits. The issue with that is that the notice of appeal was filed on September 3rd, 2021. But the order of partition was filed on March 5th, 2021. There was 182 days that passed in between the notice of appeal being filed. And really, the rule says that jurisdiction of the court must be invoked within 30 days of rendition of the order to be reviewed. I mean, it's way past that. So on its face, we'd say that it's in violation of the time. But to go deeper into that, the order of partition is kind of a hybrid order. It has final orders in it. It has non-final orders in it. And we say that it is untimely appeal as to those final orders within the order of partition. Specifically, that order orders that the property at issue will be partitioned and sold at a judicial sale within 60 days from the date of the order. It says that the parties must take all necessary steps to make sure that that sale happens. It imposes the constructive trust in the amount of $108,339. It then says that after imposition of the constructive trust, the parties are to equally divide the proceeds of the sale. And then it says that the parties are to share in the costs of the maintenance and upkeep up until the time of the sale. There's nothing about any of those things that changed in any way in any subsequent order. The constructive trust is imposed in that amount. That part is not, it's just put into effect in the final order of the county. But there's no other judicial labor that took place as far as that constructive trust. And we'd say that if they wanted to appeal the imposition of that constructive trust, the time to do it was within 30 days of March 5th, 2021. Now, the only other non-final orders within that order of partition relate to two reservations of jurisdiction. And that is for the court to determine additional credits to the parties after the trial, in between the trial and the closing, and then to determine attorney's fees and costs.
And if I can, counsel, I'd like to kind of point you and ask about the attorney's fees just a minute if I can. Recalling the briefing, your client's position is that the failure of appellant to file a motion was fatal to any claim for attorney's fees by appellant or the defendant below. Is that right?
That is our position.
So, looking at section 64081, what in the text, the plain text of that, why is the motion necessary?
Well, Your Honor, Rule 1.525 of the Rules of Civil Procedure says that any party seeking a judgment of tax and costs or attorney's fees or both shall serve the motion no later than 30 days after the filing of the judgment. They're trying to seek an award of attorney's fees. That's why the issue of their entitlement was never discussed in that attorney fee hearing. I mean, there's also no transcript of that attorney fee hearing. And there's a case from EA Produce versus Superior Garlic. It says, without a transcript, the record is inadequate for us to review as to attorney's fees, and the trial court's orders and judgments must therefore stand.
And the lack of record, I think, certainly in many cases can be highly problematic. I would grant you that. If this were a prevailing party posture, if this were a situation where statute vested in your client the legal right to an award of attorney's fees, and then the attorney's fees were not sought by the filing of a motion, I think your argument's well taken, and I'll candor with you. Is this statute, is 64.081, materially different than, say, a statute that awards attorney's fees to a prevailing party? This statute, different than what I just discussed, where a statute awards a right to a prevailing party, this statute imposes a burden and a right on all parties that are owners of the property. Does it not?
It does and it doesn't, Your Honor. I think that's part of why we're here. And I would also kind of defer back to what Judge Jay was just mentioning before. I mean, there is something to be said about a motion having to be filed. So, but you know, on top of that, Your Honor, the plaintiff appellant's or the defendant appellant's own briefing on this, their response to this motion to refer to attorney's fees, argued that nobody should get attorney's fees. So they're trying to have it both ways here, and I don't think it's appropriate when we follow exactly what was needed to be done and presented to the court. I understand that they attached affidavits to their response to our motion, but they never specifically moved the court in asking for an award of attorney's fees.
And nobody's questioning, sir, I'll speak for myself. Certainly, no, I'm not questioning the propriety of you filing a motion, putting it before, but that's not before us, it's not questioned, frankly. I think you're wise to file a motion. My question is simply this: 64081, as it is written, is substantially different than other statutes awarding attorney's fees. This statute seems to me to flatly say that the judgment, which belongs uniquely to the court, the judgment shall allot fees. And I'm paraphrasing, obviously, but then you are to judge under equitable circumstances, considering the percentage of ownership and perhaps other equitable circumstances, or other equitable considerations. You are to award fees to plaintiff or defendant or both if services are rendered that benefit the petition. And is that wording and the difference material, number one? And if so, is it determinative as to the effect of appellant's failure to file a motion in the trial?
Well, Your Honor, I guess it comes back to the benefit that was provided from the attorneys in effectuating the partition. You know, I would say that there's something to argue there. I mean, Judge Daniel's order of partition said that everybody's supposed to split the costs of everything after this, right? And he was really concerned about that in the trial at the end of it. He said something to the effect of, I really can't leave this out here right now. If somebody's gonna plant a flag here and not help out and share in the costs, that's not gonna work. So it needs to be written out. But you know what happened? The exact opposite of that. The appellant refused to pay anything to help out with that property after that trial. And it became my client's responsibility to pay for all of the maintenance, upkeep, mortgage, insurance, taxes, everything during that entire time. And so I think that probably played into part of Judge Daniels' rationale when we went into the attorney fee hearing, because his order was directly not followed by the appellant.
And so your argument is that's an equitable consideration that would have led potentially to his determination as to fees.
Absolutely.
Is silence in the order to that effect enough in the absence of a transcript?
I think it is in absence of the transcript and the case law that I cited.
Okay. I'm sorry.
Beyond the motion to strike, let's talk about the imposition of the constructive trust. The way that Judge Daniel got to that constructive trust, it was all that this trial, the threshold issue in this trial was this purchase price money a gift or not, right? And that's separate from the other credits here. The Biondo case even says that, let me find it exactly. It says that while a party may be credited for payment of a purchase price in a partition accounting, the question of whether to include the purchase price in a partition accounting is determined by the party's intent. And so that's why it all became about the intent behind this purchase price, this $108,339. And Judge Daniel found with clear and convincing evidence that it was not to be a gift. And so that created a dilemma for the court. I understand Ms. Fox's argument that there was no unjust enrichment play. But this was an issue that was raised in the middle of, that came up in the middle of the trial. I mean, when Judge Daniel determined that it wasn't a gift, he had to figure out a way to allocate that $108,000.
So your position is described by consent?
I'm sorry, Your Honor?
Your client's position is that was tried by consent?
Yes, Your Honor. And in fact, the whole questioning of the constructive trust and whether or not the amount of money could come off the top or be a credit was absolutely discussed. I can point you to the record.
Was it ever argued below that it was not pleaded?
It was never argued below that it was not pleaded. It was never argued below that they didn't receive due process.
And the parties were asked for order to provide supplemental briefing, were they not?
They were, and the appellant took an extra bite at the apple to directly address the constructive trust. At the end of the trial, Judge Daniel said, okay, this $108,000 is an issue that you guys didn't give me enough to figure out. So we're going to brief it. And he gave us some time to do it. And then in the meantime, we had some back and forth about whether we're going to have a judicial sale or a private sale. And then it kind of came roundabout back to Judge Daniel. He ordered us by January 15th to provide the briefing on it. So everybody did, but 25 days later, in our briefing, we discussed the constructive trust. 25 days later, after the appellant provided her original brief, she provided a second one that directly addressed whether the constructive trust was appropriate or not. Judge Daniel even recognized that and acknowledged that in the order of partition that she had argued it. And he still imposed the constructive trust in equity to do justice by my client, Ms. Florence Cassiano. Because the other rationale to it is, okay, she spent that $108,000 on the purchase price, closing cost down payment for this home. When she spent that money, the appellant, Alex Cassiano, she had no interest in the home at that time. And so how is it fair for her to have a cut 50% of that money when it was not a gift. So that created a dilemma for Judge Daniel to say, okay, well, how are we going to do it? We briefed that and came up and provided the constructive trust, the resulting trust ideas as a way to make it happen, other than just trying to take it off the top. But I argued in the trial that it was possible, I didn't think the constructive trust was even necessary at the beginning. I thought the Beyond Bill case that proposition that I just mentioned, it says, a party can be credited for a purchase price in a partition accounting, but the question whether to include it in the partition accounting is determined by the party's intent. So to me, that means that if it was a gift, then it would be included in the partition accounting and then be credited and split 50-50. But because it is not a gift, it is outside of the credits that are handed out in the partition accounting, and that's why it came off the top. But I think that case alone could have allowed the same effect as the constructive trust. But I still think that it was done in equity and fairness and justice to Ms. Cassiano because of the finding that it wasn't a gift. Another consideration here is the recalculation of the final order of accounting. Depending on how the court rules on the attorney's fees issue, obviously it potentially would have to get recalculated. We believe that our position is that it wouldn't get recalculated because we believe the attorney's fees are appropriate. The other issue is the rental offset, the rental value offset that was provided to Ms. Cassiano. We believe that it was done properly. The only other way if you look at the Barrow versus Barrow case, it talks about if a co-tenant in possession makes a claim for maintenance or expenses in the upkeep of the home, then the co-tenant out of possession is able to get that rental offset value. And it's just an offset up to the amount of the rent that is proportionate to that person. So in this case, it was 2 years worth of rent that she missed out on, $113,000 total. So then half that is like $56,000. And so that's the total amount that could get applied to the appellant's credits. And we had a total offset at trial. The way Judge Daniel did it was, the credits that were provided by each party at the trial, we came up with 47,000 some odd. They came up with 91,000 some odd. And we stipulated in the trial to all of their credits. They didn't stipulate to our credits at all. They made me go through each and every single credit that Ms. Cassiano was claiming. And then they never revisited it. I mean, now they're trying to say that there's $12,000 some odd dollars that shouldn't have been credited to my client. But that was never raised in the trial. They never specifically went back in any way and cross-examined my client and put those documents that were entered into evidence without objection and said, why are you claiming this? Why are you claiming this? And that never happened. There was never any dispute to those credits. In fact, her trial counsel even acknowledged that we were claiming $47,000, they were claiming $91,000, and that's how it all came down to. There was a discussion in the transcript about, how it's split. It's a 50-50 share. So the difference between those of the 91 and the 47 is 44,000. You split it in half, and then it's 22,000. That was the original credit that was going to get applied to Alex Cassiano, the appellant, at the trial. That was the calculation that was made. And then the rental value offset was applied to that number. It was 56,000 versus 22,000, but it's zeroed out, right? And so from there, we had to go to the judicial sale. And then when we came back with the additional credits and attorney's fee stuff, that's how Judge Daniel added everything up and figured it out.
Your client never challenged before this court the zeroing out, as you just raised. Right?
I'm sorry, no?
You did not challenge before this court, you did not appeal his zeroing out of the attorney's fees as compared to credit allotments, but even though your client would have benefited more had you not zeroed it out.
In fact, Your Honor, he didn't zero out the attorney's fees. The attorney's fees.
Not the fees, not the, then maybe I missed it. He zeroed out credits from rental value. Credits, the difference in credits from appellant to appellee, and then compared the rental value to 1/2 interest in the rental value. The credits that would have been afforded towards your client in that credit was less than the rental value of $56,000 that would have been owed to your client, correct?
Well, yes, Your Honor, it's the $22,000 credit went to the appellant because she had $91,000 and we had 47, and you subtract and divide by 2, correct? We had $56,000 in a rental value that offset the 22 and it made it 0. And then we went to then when we finally went in front for the attorney's fees, Judge Daniel added up the attorney's fees as a credit, plus our costs as a credit, and then he added in the additional post-trial credits to Ms. Cassiano for all of the mortgage payments and everything she had to pay when the appellant didn't follow Judge Daniel's order.
Okay.
So the only reason I mention that is because if there was to be a recalculation, the only way that a recalculation would make sense is if the attorney's fees and the costs are not included in that calculation. They're separate from, the way that Ms. Bogus has presented it is to add everything up. And you can't add everything up and divide by 2 like that. When you're going to apply the rental value offset. The rental value offset can only be applied to the number for the expenses and the maintenance fees. And so our position is Judge Daniel did that properly, and that the orders of the court should be affirmed. I have nothing further, unless the panel has any questions. Otherwise, I'll rely on the merits of my brief.
Thank you.
Thank you, Your Honor.
Rebuttal?
Thank you, Your Honor. As to the attorney's fees, the order on plaintiff's amended motion for attorney's fees and costs specifically discusses the requirements of the statute, and the court itself talks about the apportionment being required. The majority interest shall be on the greater portion as well as to the attorney for the minority interest. So the judge itself recognized that that the statute required there to be awards to both the majority or minority, or in this case, the co-owners. And we've also cited in our briefs a plethora of several cases where it talks about error and where you only award one side attorney's fees. And we've talked about potential exceptions in which apply here.
What relevance is there to the lack of transcript of the attorney fee hearing?
Well, it would be an issue if we were debating what awards were given and the factual findings, because you could not. It would also perhaps be an issue if there's an error on the face of the order itself.
Would it be relevant to determine what equitable considerations Judge Daniel reflected upon?
Well, it would if we were arguing that we made a benefit, that the attorneys made a benefit to the partition, and he found that we did not. That would be a problem. But he found that...
What if there's contemplations that vexatious litigation or the nature of litigation was such that it would overcome any benefit conferred by defendant's trial counsel?
That is not a finding that was made. It is not.
I know it's not on the face of his order, but I know that.
No, because he did not make an award, and he did not make a determination that they weren't entitled to an award. What he did was he did. He made a determination that he wasn't going to award it in the accounting, but he did make a determination after discussing the case law.
But Ms. Bogus, I think Judge South's point is, how do we know he didn't verbalize that at the hearing? Because we don't have a transcript, one way or the other.
Well, our recommendation would be to the court is, given the finding that the attorneys benefited the partition, that it should be reversed, remanded. On remand, Judge Daniels would be the person who is going to make the determination as to what attorney's fees are recoverable on behalf of my client.
I think our question is, let's say we wholeheartedly 100% agree with you. How do we overcome our presumption of correctness about that hearing without a transcript?
Well, the presumption of correctness is in the judge's order, in which the judge said that my client's attorneys benefited the partition. No one has attacked that finding, no one has attacked that ruling. And given Judge Daniels' ruling, he actually made an error in not going to the next step and determining. If in fact he determines that it was vexatious, then we could be maybe back up here on the attorney fee thing, but that's a different issue.
To be sure, it looks as though one side was awarded attorney's fees and one
Right.
side wasn't. How do we know that that wasn't proportional to the amount that he found them to contribute? It doesn't look that way, I can see. However, we don't have a transcript to confirm.
That would only be proportionate if he said they did not benefit, because you cannot benefit the partition and be entitled to 0%. And the order itself talks about the majority and minority. Frankly, I think the argument that the motion had not been filed is what happened here. But again, I don't have the transcript. What I do know is based on his own finding and the presumption of correctness in the trial judge who made the determination that it benefited the petition, he did not find. And he did not stay in there that it just, that the attorney's actions made the petition more difficult. Given that finding, he had to go forward and award fees, and it's an error under the case law.
May I know she's back time. May I ask a question?
You may.
So, the statute 64081, which everybody I think is very familiar with, every party shall be bound by the judgment to pay a share of costs, including attorney's fees, to plaintiffs or defendants' attorneys, or to each of them, commensurate with their services rendered and of benefit to the petition. Here's the part I wanted to get to. To be determined on equitable principles in proportion to the party's interest.
Right.
So, how do you present that language, equitable principles in proportion to the party's interest? Is the only equitable principle available the interest of the parties to the property, or is it beyond a sheer calculation of interest in the property?
The attorney's fees are credit. They are a credit just like others. And under Biondo and O'Donnell, the equitable principles that are discussed in 64081 are the same one as 64071. You basically combine that, you basically compare the credits and you do the calculation based upon the proportionate share. That is the equitable, that's how it's unwinding to make it equal. In other words, you may have spent more attorney's fees, but you had a lesser interest. So that's how the equitable apportionment is done.
Am I hearing your answer to be that the equitable considerations are simply what is the proportionate interest in the property?
What's the proportionate interest as a credit? That's the whole Biondo and O'Donnell, where you have the percentage of ownership, and then you have the credits. And then you go through that whole calculation and comparing the credits and all that.
And I understand that, and I don't want to go down a rabbit trail. But I mean, this is an enforceable judgment. I mean, the statute even says it's enforceable against chattel property, et cetera. So I don't know that it's just a credit against a surplus. If the credit exceeds the surplus, is it not an enforceable judgment?
The ultimate judgment is how much of the surplus comes out. The attorney's fees itself is not a separate damage award, and there's case law in there that we've cited. It is a credit that goes into partition accounting. We have equitable accounting that's governed by the case law, O'Donnell and Biondo, and that would be the same process that would be followed here. And my time is up, so thank you, Your Honor, and we request the relief in our briefs. Thank you.
Thank you, Ms. Vargas. Thank you both for a well-presented argument. We are officially in recess.
Just need to